in the name of personal injury law.
When we hear about a car crash, we often ask, who caused the accident? At-fault drivers are not only exposed to criminal liability, but they can also be sued in civil court for the injuries they have caused. Today we have with us Steve Sinas, a personal injury attorney at the Sinas law firm, and he's going to help us understand Michigan law and fault as it pertains to auto accidents.
Thanks for having me.
So, why does determining fault for the crash matter under Michigan law?
So fault makes a big difference when you're looking at a crash for a number of reasons. First of all, for the people involved, if they are found to be at fault, they may face criminal penalties. They may have to appear in court. They may be charged with something like a traffic citation or even like a misdemeanor or potentially a felony. But that's criminal law. There's also civil cases that can be brought against at-fault drivers.
And those are the cases you work on?
Yes.
Yeah.
And so when a person is injured, they're trying to figure out what their claims are that they can bring in relation to their injuries. They have the right to potentially pursue Michigan no-fault insurance benefits. That's for the medical care, that's for loss of income for a limited amount of time. Those are payable regardless of fault. That's why they're called no fault. So actually fault doesn't really matter when you're talking about those benefits. But when you're talking about the person's pain and suffering damages, their long-term income loss that's not recoverable under no fault, those are the damages they can bring against the at-fault driver. So when they're considering whether they have those claims, they have to look at how did the crash occur, who did what, so we can determine whether or not fault can be satisfied for purposes of that civil case.
So tell us about comparative negligence when maybe both drivers are partially at fault.
Right. So when you're talking about how to determine fault and this concept of negligence, let me first start with the explanation in terms of the defendant in the personal injury case. The plaintiff brings the case against the defendant saying they failed to use reasonable care in operating their vehicle. There's a number of ways they can show that. They can show that the driver failed to follow the Michigan Motor Vehicle Code, that the driver wasn't paying attention, that the driver had an opportunity to stop or avoid the crash and they didn't. But it's all under this standard that the driver didn't use reasonable care. But the defendant can point the finger back at the plaintiff and say, you also didn't use reasonable care. I may have run the stop sign, but you were speeding. I may have turned out in front of you, but you could have seen me and avoided the crash. There are a number of different arguments they can make back to the plaintiff. I should also say that defendants can also say, yeah, I did something wrong. Yeah, I violated the Michigan Motor Vehicle Code. Yeah, I hit you, but there was a sudden emergency that I was confronted with, like bad weather all of a sudden, or I had a medical condition, or something came upon my path of travel that was unexpected. So yes, I was negligent, but there was a sudden emergency that negates my negligence. Mm-hmm. So there are these concepts that play into this analysis that can really be affected by the specific facts and circumstances of a case.
So does the injured person have to file a lawsuit in order to establish negligence?
No, not necessarily. What people should do is they should understand what the evidence is in terms of what happened in the crash, what the police said, what the witnesses have said, what they remember. And if the evidence really shows that another party's at fault, the injured person through their attorneys can contact that at-fault driver, and usually is connected then with their insurance company, and try to exchange information about the crash and get an assessment of fault that everybody agrees on. And even though they have adverse parties involved, when the plaintiff presents the information to the defendant's insurer before a lawsuit, the insurer might say, hey, we understand our person's at fault. We want to resolve this claim with you. Please present us the information of what your injuries are. We acknowledge that our driver was negligent, and some cases can get resolved that way.
So could you give us some examples from the cases that you've handled where the other side is claiming your client was comparatively negligent?
Right. So if you can't settle the case and fault's in dispute, the plaintiff goes forward and files the lawsuit. And in doing so, like I said, the defendant can point back at the plaintiff. And just to give the viewers a couple examples, I had a case where my client was driving the front seat and the driver turned left and shouldn't have, and then the car got T-boned. And it was nothing more than driver error in terms of her decision to turn left, but she had drank 2 glasses of wine. And when her defense lawyers got in the case, they argued that it was comparatively negligent for my client to get in the vehicle with somebody who drank 2 glasses of wine at dinner. The case was litigated. There was no showing from any toxicologist or any other expert that alcohol contributed to the crash. She wasn't swerving the lane. She just didn't see the car. And so we fought against this argument that, the defendant shouldn't have turned, but it's really my client's fault for getting in the car with her. I also have a pedestrian case where it was a hit and run, where the driver hit my client. She was not walking at a crosswalk, but she was there to be seen. And we were able to show through the lighting and everything else that was there on the roadway that the driver should have seen her and stopped, rather than she got hit and he drove away.
Right. So from some of the cases you've worked on, can you give us an example of where the other side has claimed that they had a sudden emergency that basically excuses them from causing the accident?
Yeah, one that comes to mind is a wrongful death case I handled for a Michigan family. Actually, the death occurred down in Florida, but the at-fault driver was on his way to get his prescription medication. He was a diabetic, and he had a seizure while driving. And so they initially argued that that was a medical emergency. He didn't know he was going to have a seizure. But we were able to show that he knew that he could have a seizure, and that getting behind the wheel, especially when he didn't have his medication, was a negligent decision. It was something he knew he had the risk of being susceptible to, and that's exactly what happened. He had the seizure and lost control of the car. So that's an example that comes to mind.
Well, can the defendant in the civil case blame other people, not your client, the plaintiff, for example, but other people who are around for the accident? Yeah,
so an injured person can sue an at-fault driver and make that person be the defendant in the case, but then the defendant can point the finger at non-parties and file what the law refers to as a notice of non-party at fault. And it's the defendant asserting in the case that it's not them, it's someone else. And when that happens, the plaintiff then has to make the decision whether they're going to add that other party to the case and bring them to the litigation. And that's usually what happens.
Well, can you give an example of where there's been, the defendant has tried to bring in a non-party at fault?
Yeah, one common example is when there's a showing that the person's airbag didn't work or some defect in the plaintiff's motor vehicle that contributed to their injuries. So the driver that hit them will argue, yeah, I hit them, but they would have not been as injured if the airbag worked. So they'll notice a non-party at fault, the auto manufacturer or whoever is responsible for the airbag. But one ridiculous one that comes to mind was a case I handled where the at-fault driver blew a stop sign, hit my client. She was doing nothing wrong, but he argued that he was frightened by somebody who had a bow and arrow in his hands on his own property on the roadway, and that he thought he was pointing it at him, and so he got distracted and didn't see the stop sign and drove into my client. It was a bow and arrow. He was in his car. But he filed the notice of non-party fault, and we had to sue the person with the bow and arrow. But luckily, the case all fell back on the at-fault driver, as it should have been, because the facts didn't support bringing fault against the other person.
So when is it a good time to contact an attorney such as yourself to figure all these nuances out?
If you're seriously injured, you really need to consider your rights against the at-fault driver. If there's any dispute about fault in terms of how the accident happened, you need to make sure that you're collecting your evidence and building your case. So the more serious the injury, the more disputes there are in fault, the more reason there is to contact an attorney early on. Some people can go it alone, but I suggest certainly consulting an attorney.
Agreed. Thank you, Steve.
Thank you.
In the Name of Personal Injury Law is brought to you by the Sinas Law Firm.